Hello, I'm professional attorney and very much amateur musician Scott Lesowitz, and today I'm going to be discussing 3 points about Phil from Wings of Pegasus's recent video on copyright law. Now, I want to emphasize at the beginning that I think Phil did a good job. I think he's a knowledgeable guy. I don't want this to be coming off critical. All right, with that said, my first point is going to be about this clip from his video.
So, even though everything that I upload is fair use,
so I doubt that all of Phil's videos constitute fair use. I think a lot of them do, but I doubt that a judge would find every single video to constitute fair use in its entirety. The biggest problem that Phil tends to have on some of his videos that I've seen is the length of some of the clips he'll play from a song without commenting on it. So I just picked kind of a random video to look at. Recently he posted a video about Bobby McFerrin, a live performance of Bobby McFerrin, and early on in the video he plays close to 2.5 minutes of the song before he makes any comments. The problem he's facing is that one of the factors of fair use is the amount and substantiality of the portion used. Seminal case from the Ninth Circuit. There was a documentary about Elvis that used a lot of clips of Elvis performing on TV. And the Ninth Circuit found that a lot of the use of the clips did not constitute fair use for, among other reasons, because oftentimes they would play unnecessarily long clips without commenting on most of what was being played. Now that said, you could still use quite a bit of the original if necessary for your legitimate fair use purpose. The thing that comes to my mind is when Phil plays a lot of the vocals from an original in order to illustrate how he knows and how the person is using auto-tune or pitch correction. You can't just play 3 or 4 seconds of a song in order to illustrate and show how the person's using pitch correction. You got to use quite a bit. Okay, the second clip I'm going to react to is this.
a copyright claim. A claim is just somebody taking the ad revenue, but you can still upload your video. As much as you think what you're doing is fair use, and you might know it's fair use, as I do, the copyright claim means that the artist or the copyright owner is taking that ad revenue. And I don't have too much of a problem with that. I mean, it would be great to get paid for the work that I put into each video.
All right, so my big comment here is, Phil, you're leaving money on the table, man. Okay, this is an important concept. Fair use equals free use. If something constitutes fair use, there's no need to pay the copyright holder. The copyright holder is not entitled to 1 cent. Basically, the way copyright law views it is that copyright of an original song or whatever is being copyrighted does not extend to fair uses of that material. So the way the Content ID system works is that the system will initially automatically, without any user input, flag that the video has part of a copyrighted song in it, and it will automatically demonetize the video to whatever extent the agreement with the copyright holder is. However, the person who made the video can dispute the Content ID claim. And the first time you dispute it, there really is no risk, because at that point the copyright owner has to look to see if they want to reinstate the claim. And my understanding is that oftentimes if a fair use claim is made in the dispute, the copyright owner will not reinstate the claim. So there you go. A lot of the times you're going to get the money. And if they do reinstate the claim, if they choose to reinstate the claim, at that point there's no copyright strike. All right, and that leads me into the third clip, which is still kind of related to the second one.
This is another thing to be aware of, is that some copyright owners do this. They brandish a copyright strike regardless of how you've used the copyright material and how within the law it may be.
Only get a copyright strike on YouTube if the copyright owner sends in to YouTube a formal DMCA takedown notice. That's a legal takedown request, as opposed to the Content ID system, which is really not a legal system. And in order to send a DMCA takedown request, the copyright owner has to swear under penalty of perjury that they have a good faith belief that the person who made the video violated their copyright. And under the law, the copyright owner must consider before sending the notice whether the content, the allegedly infringing content, does or does not constitute fair use. And the YouTube takedown notices, which have to be done manually, they cannot be done through an automated process, they actually refer to fair use in them. But let's say if Phil has a video that he knows is fair use, he didn't use too much of the original, he's using what he used for analysis purposes. Again, I'm thinking a lot of those pitch correction videos where really, you got to use quite a bit of the material. Phil could theoretically, if he gets a copyright strike, dispute it. And then if he disputes it, the copyright owner would have to file a lawsuit in order to have the copyright strike reinstated. And if they file a lawsuit and it's clearly fair use, they risk losing the lawsuit and having to pay Phil's attorney's fees. That said, I know it's a lot of risk, and from what I can tell, virtually no one on YouTube takes this risk, especially in the music sphere. And because of that, there's very little litigation to look at and to point to. And this is unfortunate because nobody disputes this and nobody takes it all the way, the record companies basically feel like they have free rein. It encourages bullying. All right, with that, hopefully that was helpful, and take care.